Welcome everyone to our latest Disputes Nightmare Scenario Flash webinar. The subject of this edition is what to do if you discovered that a senior employee had stolen your confidential information to take to a competitor. I'm Euan McMahon. I'm a Managing Associate in Mishcon's Fraud and Dispute Resolution team, and I'll introduce the other speakers very shortly. But first, I'll just sketch out our nightmare scenario. So you operate a business that has a lot of very valuable intellectual property and confidential information, and the senior employee has just handed in their notice. They're currently on gardening leave, and you receive an automated notification while they're on gardening leave that from your document management system that the employee has attempted to access various files that they're not authorized to view. And so this obviously prompts a check of their activity, and it reveals that they appear to have downloaded significant amounts of confidential information in the last few weeks, and there's no clear business reason for them having done so. So your obvious concern is that the employee intends to take that confidential information to a competitor. Here to discuss it with me is Martin Boyle. Martin was formerly at Slaughter and May, but he's been with Ocado for about 6 years now, previously as a head of employment and disputes, and he's currently interim deputy general counsel. And also with me is Sharon Tan, who is a partner in Mishcon's employment team and advises on all aspects of contentious and non-contentious employment law. Just before we kick off, I'll just say, if you'd like to ask a question, please put them in the chat, and if we have time at the end, we will answer some. So, Martin, this scenario won't sound entirely unfamiliar to you. Obviously, it's pretty closely based on real events that happened to Ocado and that we dealt with together. In a situation like this, from a business's perspective, what are your first steps going to be?
Thanks, Ian. And yes, I think the title of the series Nightmare Scenarios is pretty accurate, because it was a bit of a nightmare scenario. So for us, the initial kind of steps were, upon being notified that this had happened, is to, first of all, have the initial conversations that you need to have with the necessary senior leaders across the business to make them aware that this has happened. That is in large part to make sure that you are wrapping your arms around this and making sure that it is legal is the function that is leading on any potential investigation. And the obvious reasons for that, will be because we need to control, where the investigation goes, what potential outcomes are, but also to make sure that we're protecting and utilizing privilege as much as possible in any of the documentation that's generated. What those conversations are and who those senior leaders will be will very much depend upon the nature of the circumstances. But you'll also have to engage with other individuals. And again, it's very much dependent on the situation. It's not possible to have a fully worked out playbook for these scenarios. So you may have to engage with the individual's direct line managers. You may have to deal with some elements of their team. You'll have to engage with your IT function. So, you very quickly have to understand who is likely to be involved in creating almost like a mini working group to help you conduct the investigation. And, what you'll want to think about upfront as well is around, confidentiality and risks of leaks. So using things like project or code names for the investigation itself and or for individuals who may be the subject of the investigation. But what you're first of all doing really, once you've done those kind of high level, points, is to look at what information is it that, you're looking at. What areas of the business does the employee work in, who they work with, what information have they taken, and who what do they have access to? That's probably the most critical point, because you very quickly want to understand what's the scale of the risk the organization is looking at. Are you looking at a potential regulatory issue? Is there personal data involved? Is there going to be an ICO report that needs to be made? You really need to get to that really quickly. So looking at the value of that as well, and how important it is to the business, what's the commercial impact of it?
Yeah,
and then
oh, sorry, go ahead.
I was just going to say, and then trying to understand what use they might be making of it. Are they going to have they taken it for a specific purpose? Most likely it'll be to use with a potential competitor in the future. But you can't just, as some people who will be familiar with some other cases where you could have rogue actors who are acting for malicious purposes as well. So you also need to understand who else is involved potentially outside of the business. What's the network of the individual involved? So there's a lot to get to gather in a short period of time.
Yeah, absolutely. I think answering those kind of key questions as quickly as possible is going to be vital. And as you said, I think it can be difficulty of doing that can be kind of compounded if you don't really know exactly where that employee may sit within the business, or who they have connections with, who their team is, who their friends are. All of that can make the answering those questions quite tricky.
Yeah, and you have to tread quite carefully with, again, one of the biggest mistakes you could make is blunder into having conversations with people and you don't actually know what relationships there may be. And so you have to you do have to have take a lot of care in the conversations and try to ascertain as much information as possible at senior levels first, where there's a higher potentially degree of knowledge and trust with the individuals who you may be speaking to try and understand what the lay of the land is really that you're stepping into. Because as you say, in big organizations, you may never have really engaged with this particular team or this particular area of the business before, and you have to get up to speed on it and what they do very quickly.
Yeah. And just in terms of you're having those conversations, you're trying to answer those questions, what sort of things are you doing in terms of gathering and securing evidence, as in kind of documentary evidence?
Yeah, so it's pretty standard stuff that you would expect. It's suspending any deletion policies, any automatic deletion policies that might be relevant for some of the data sources that you might be looking for. You'll be looking at identifying where is the potential sources of evidence. So things like automatic backups of devices. Can you obtain backups or can you do a remote backup if possible? You're looking at things like what's on the employee's laptop. They're taking a download potentially of their mailbox, and ideally trying to get a backup of their phone if possible. However, and we'll come to this later, depending on what is the primary concern for the business at the time, you need to be careful of really understanding before you do some of these things if you may be tipping the individual off to the fact that you're carrying out the investigation, which I know we'll come to. But the one thing I would say, just as a practical point, and it may be different in different organizations, but some of what you're undertaking can be very technical and very time consuming. So starting early, you will need to look, form a very close relationship with your a reliable and trusted member of your IT team who can guide you through some of the fairly basic questions that you'll have to ask in terms of understanding what has actually happened. And the thing is that my one tip on this is that there are no stupid questions on this, because you really, in my view, whenever I was leading on this investigation, you're stepping into very technical systems that you just don't know what you don't know. And so you have to ask loads and loads of questions to really understand how it works, both to be able to translate it for external counsel or potentially to a judge at some point, but also so that you don't necessarily miss making a connection or miss a potential avenue of further investigation. So asking lots of really basic and obvious questions and working with somebody in IT can be really critical.
Yeah.
And also, just finally on the timings point, not only does it take time to get up to speed, but finally it can take, because of the size of some of the data sets that you might be downloading, it can actually take quite a long time to get a hold of, lots of mailboxes and lots of, people's, storage drives and things like that. So the earlier you can get on that, the better.
Yeah, no, absolutely. And as we know, in our particular case, it ended up taking a surprising, I think, amount of time for both of us to get a hold of this kind of stuff. And we were talking about mailboxes with potentially millions of items in them. So let's say we've done that now. We've set up the investigatory team, and we've secured the evidence, and perhaps we've started looking through it. Sharon, from your perspective, what would you be doing next in terms of further investigation?
Thanks, Euan, and thanks, Martin. Having carried out that initial investigation that Martin's outlined, you might discover, or you might in fact have reason to suspect, that the resignation of a senior employee and the attempted theft of your confidential information is actually only the tip of the iceberg. What you often find in this situation is that a competitor has actually tried to recruit an entire team of your key employees. And the question then becomes, well, what do you do if you find that actually this looks like part of a larger plan to ransack your business? What's the next practical step? In that situation, really, the first order of business is to find out how far and how wide the attempted raid extends, because you're going to need to identify those who are potential flight risks so that you can take steps to secure key talent if that's what you need to do. And you might also find that you need to secure critical client relationships. But as a practical matter, one of the first things you really want to do is to identify, as Martin says, who the departing employee has been working with, who they're close to, because you're going to want to talk to those people fairly quickly. You're going to want to get them into a room so that you can ascertain whether they themselves have been approached. You're going to want to take the opportunity to remind them of any continuing obligations that they owe to you. Fidelity, loyalty, they might have post-termination restrictions that you want to talk about if you think they're on the cusp of leaving. And crucially, you're also going to want to find out what on earth has happened to your confidential information, what's been taken, where has it gone, and you're also going to want to find out the identity of any third parties into whose hands that confidential information might have fallen. And then really the next practical thing for you to think about in real terms is what you do about what you've uncovered. And obviously that will depend on what you find when you talk to people. But you might want to be thinking about things like retention bonuses. Do you need to think about incentivizing people to stay, to stabilize the business, and really to lock down both the confidential information and the people that you need to protect the business going forward? One other practical point just to think about is that in our scenario, the individual who downloaded a lot of the information was on garden leave already. And, quite frankly, if somebody's on garden leave, they've got no good reason to have continuing access to your systems. And so to some degree, it's a step that you might want to think about fairly promptly in all cases if you're putting people on garden leave. But if you haven't already done that, you would probably want to think about cutting off access to the system to make sure that you at least limit the size and scale of the problem that you're dealing with. So if, having spoken to all of these people, you think that some of your employees might have acted in breach of their contractual obligations, or if you think that they might be intending to, whether that's confidentiality obligations and making sure that they keep your confidential information secure, or whether you think that they're at risk of starting work for a competitor in breach of a non-compete, then in those circumstances, the next thing you probably want to be doing is to write to them to remind them of the contractual obligations they're subject to, and you would also ask them for a series of undertakings. And those undertakings are generally designed both to flush out any misbehaviour that's occurred already so that you can get to grips with what's actually happened. And you're also seeking to extract a commitment from them to make sure that they're going to adhere to those obligations in future. The other part of the puzzle is, of course, to look at the competitor who you think has been raiding your business or trying to. So you will also want to be writing to them to let them know that you know what they've been up to make sure that they're fixed with knowledge of any contractual obligations that your employees are subject to, and really to request undertakings from them too, which are again designed to try to identify any wrongdoing that's happened so far, and also really to put them under pressure to confirm that they're not going to do anything unlawful in future, such as hire a bunch of your employees in breach of the non-compete. And the hope, of course, is that whenever they receive those letters, they'll see the error of their ways, they'll return any confidential information and agree not to hire anybody in breach of any non-competes. But, they might not do so. And if they don't, you might need to consider whether further action is necessary, such as seeking an injunction to secure compliance.
Yeah, I think definitely if your investigation reveals that a team move is on the horizon, and that's the business's primary concern, that is the issue, then that's certainly, obviously, that's the route that you want to go down, what we might call the kind of, I suppose, on notice route. In other words, letting the employee know fairly soon about what you know. There is a kind of alternative route if the primary concern, having done your investigation, is that it's the confidential information is your concern. It's very valuable. Perhaps there's a risk that the employee will seek to delete or conceal the incriminating evidence. In that kind of situation, then you're probably going to want to take a slightly different tact in the way that you approach things, in that you're not going to want to let the employee know that they're under suspicion while you're carrying out the investigation. The obvious reason being that they may well start taking steps to hide their tracks or delete evidence. And in those kind of situations, the investigation needs to be carried out quite carefully, because there's a number of ways, as Martin alluded to before, that an employee might be alerted or tipped off. The most obvious one is obviously if you send a notice of disciplinary or suspension, something like that. So you're going to want to hold off doing that for the time being. But there are less obvious avenues. So leaks from inside the business, again, Martin, you mentioned that. That's a kind of key one. Employees have connections, they have friendships, and you may well not know who they're close to, who they speak to. And there may be co-conspirators as well. There may be other people involved in taking this confidential information. So I do think, Martin, echoing your point, that picking the team carefully, keeping it narrow, and making sure that they know as well that the investigation is strictly confidential and not to be discussed, keeping a lock on it is absolutely essential in this kind of situation, just to make sure that the employee isn't alerted. And then the other potential way it might be brought to the employee's attention is kind of other unusual activity. Sharon, you mentioned disabling the employee's access to when they're on gardening leave. Obviously, it should have been done probably automatically. But at this stage, having found out that they are accessing confidential information, or they're trying to, it might be prudent to hold off suspending their access, if only for a little bit, if the risk is that it might tip them off that they're under suspicion. Yeah, as I say, the investigation needs to be kind of handled quite carefully and with some kind of secrecy. And really the reason for the secrecy is that you preserve the utility of certain orders that the court can make. So just running through a few that might be suitable in this scenario, you can get delivery up order, so an order requiring an employee to hand over confidential material within a set period. And sometimes that is elevated to a doorstep delivery up, where the order is served on the person at their premises and they need to hand over the information immediately there and then. Going up the scale of severity, you can obtain an imaging order. So an order, that's an order for the employee's personal electronic devices, so things like their personal phones and laptops, but also things like their personal email accounts, WhatsApp and other messaging services, but all electronic data devices are copied. And provided they've not been tipped off, the first the employee knows about it is when they are served with the order. So it's incredibly effective at preserving evidence and ensuring that it can't be destroyed or tampered with, as long as the employee isn't forewarned. And then just kind of at the top end of severity, you have a full-blown search order, which is literally a kind of a physical inspection of an employee's premises, literally going kind of room to room, collecting, going through documentation and collecting anything that's relevant or incriminating. And quite often you can combine them. So, you'll have a search, imaging, and perhaps delivery up order kind of all at once. So they're powerful and they're intrusive orders, and they come with stringent requirements, but in the right case, they are really, really effective. Obviously, as you know, Martin, in our case, that's what we ended up doing. We ended up getting search order, imaging order, and delivery up against both the employee, but also the competitor company, and ended up raiding their business premises and retrieved, large amounts of confidential information and incriminating evidence. So that's the kind of the two kind of potential avenues, and the route that you take, I think, is really just going to depend on what you find as a result of your initial investigation and what the priority for the business is. So let's say that you proceeded down one of these routes. Presumably then, Sharon, a disciplinary will come next to kind of clean house. How would you go about it, and any major pitfalls to avoid?
Actually, disciplinary action is something that people do ask about a lot in this sort of situation, and where appropriate, it should obviously undertaken promptly, in a fair manner, in the usual way, with people understanding the allegations against them and the evidence and so on and so forth. It's important, of course, that you do that to make sure that you avoid any allegations of unfair dismissal, if that's ultimately where you end up, as you might well. But the reality is that in a fast-moving situation such as this one, your primary focus is likely to be on securing your confidential information, as you've said. and protecting the business. And so really disciplinary action is something that tends to be a little bit more for the medium term, more of a secondary concern, and something that you deal with a little bit further down the line. The immediate thing that you're probably going to want to have on your radar is whether suspension, which I think you alluded to earlier, Euan, is something you want to think about, just to take somebody out of circulation and to isolate them from the business for a little while you take a look at things, assuming, of course, that you're not looking for a without notice course. But I think the one thing just to remember there is that suspension shouldn't be a knee-jerk reaction. It's not regarded as a neutral act, as it were, in the employment world, and it should only really be used where necessary and kept as short as possible. That does bring me on to another thing that is actually very important to bear in mind whenever you're dealing with this sort of thing, and it's just to make sure that you don't give your employees grounds to claim that the way that you have gone about handling matters is such that you've given them effectively what lawyers would call a repudiatory breach of their employment contract. In other words, a fundamental breach that goes to the root of the contract. So you need to be quite careful not to be too heavy-handed in the way that you engage with them, if indeed you are going to engage with them, in interviewing them and asking them questions and all of the rest of it. Because if you do, you could find that you've effectively given them the opportunity to walk away immediately from the employment contract, and also from any post-termination restrictions that might otherwise have been engaged on termination. And so you're effectively giving them a free pass to walk into the arms of a competitor, as it were. But picking up again on this point about disciplinary action, one thing that you might want to have in mind too is the range of potential sanctions that might be available to you. And depending really on how egregious the behaviour has been, and you can quite easily see how it could be fairly egregious in this kind of situation, if someone is guilty as charged, then you might want to look at whether clawback is something that you might be able to use. Oftentimes you'll find that in bonus schemes, deferral, incentive arrangements and all of the rest of it. And with a highly paid senior individual in particular, it can be a very effective tool or a weapon in your armoury that you want to have a think about.
Yeah, I think you do agree with that, Martin, given that we found it was a useful tool in the armoury.
It was, and it is. I think it's something that in a lot of situations isn't necessarily the first thing your mind goes to, but actually, if you're looking at individuals and you're trying to exert some pressure, then it can be a very effective tool. And in our case, in particular, we did clawback bonuses over the course of and shares that had vested over the course of the previous 2 or 3 years of his employment. So it was a very effective tool, and definitely one I think you should bear in mind.
Yeah, absolutely. So just very quickly, we've been talking about a kind of a data theft that has already taken place, but I think it's probably worth just briefly touching on what safeguards and other measures can be put in place to prepare yourself for that eventuality. Perhaps we can just kind of give a pointer or two from our experience. Martin, do you want to kick off?
Yeah, so for me, I think the key things for me, just in practical terms, as opposed to necessarily thinking about it from a legal perspective, is around making sure you understand how your IT systems work, understanding what the IT infrastructure is, and understanding, is it the case that it's appropriate, is there sufficient safeguards built in that would almost flag to you that this type of activity is potentially happening within the organization. Now, it's the kind of thing that there's always a balancing act between doing it in such a way that hinders people's ability to go about their day-to-day jobs, but at the same time you can do it in a way that's light touch enough that gives you the flags needed to know that somebody's doing something they otherwise shouldn't be doing. So you were looking at those red flags being things like, have people exceeded normal download limits, or have they tried to access documentation that they otherwise shouldn't have? You'll be looking at things like other flags in terms of, has somebody tried to insert a USB device into one of our IT systems? Those are all kind of the standard things you would expect if somebody's trying to take information out of your systems. They'd be looking at those. So you really want to make sure that and in a lot of people who'd be listening, that these things will be in place, but you kind of want to know that those are there to give you yourself that reassurance that you've at least got those systems in place to flag an issue, so that you can look into it.
Yeah, I think that's right. Ultimately, you're going to need to give your employees enough free rein so that they can do their jobs properly. But just, it might not be a question of kind of limiting their access, but certainly things like logs are incredibly useful. So often, you can get most modern devices and document management systems have file logs. They will record when people access things or when they print them. Making sure those are switched on, knowing what's being logged, how long it's kept for, and where the information is stored is incredibly useful. It's music to my ears when a client comes to me with that information, because one can really quickly work out what's been going on, and two, it's just great evidence that if you do need to get an order of the sort that we've talked about, it's all there. You can present it to the court, and it's very, very compelling, and you'll usually get your order off the back of it. Just very, very quickly, just in terms of monitoring employees more generally, Sharon, is there anything to be cautious of there?
Yes, I mean, you clearly ought to be making sure that you've got your house in order in terms of documents and advance notice and everything else. You should make it clear in your employee handbook and in any other employment documents that those who use your IT systems don't have any expectation of privacy, and that, frankly, anything that you send, they choose to send across your systems, you might have sight of, and that you might both monitor their communications and also monitor the data at any time.
Yeah, and just to add to that, Sharon, a point for at the very beginning of the investigation, if you are going to be accessing large amounts or any really personal data of the individuals, so for example, I've downloaded their mailbox, that you think about carrying out a data privacy impact assessment, so upfront, so that you are protecting the integrity of the investigation from future challenges on multiple grounds, so that you can show that you turned your mind to this as an organization right at the beginning.
Yeah, really good point. I entirely agree with that. And just picking up again, I suppose, if I may, on the point about documentation, I'm sure you would expect me to say that, clearly the other thing that you need to do and get right is to make sure that your employment contracts are as robust as possible. You want to make sure that you've got great confidentiality provisions in place, and that the restrictive covenants that you have are appropriately tailored so that you've got the best prospects of enforceability in the event that you do need to go and try and get an injunction to stop somebody from going to a competitor and walking off with the crown jewels of your business and all of your confidential information. The worst kind of scenario is when you kind of realise after the event that you've got in hand nothing other than an unenforceable non-compete that's fairly worthless. Yeah.
And I think likewise, the other thing to be aware of is around, similarly, to pick up on the clawback point, that you've got adequate provisions in the rules of the various bonus plans or schemes or share schemes that you've got to ensure that you've got that flexibility to either suspend or clawback payments. And on that note, another practical point is just to make sure that you are mindful of your benefits and benefits teams kind of vesting schedules. When do bonuses become payable? When are shares vesting? So that you can understand, especially in circumstances where either scenario, whether it's a team move or not, that you are understanding what's potentially going out to the individual or individuals in terms of bonuses or vesting of shares.
Yeah, absolutely. And just finally, then, the other thing is that disputes can often lead to adverse publicity. Sharon, anything that you can do to get ahead of that or to plan for that?
Yes, I mean, Martin mentioned earlier, I think the kind of the good practical step of making sure that you use code names and protect confidentiality from the get-go if you are creating records and so on that might end up in court. And it's most likely only to be relevant in terms of PR and adverse publicity, I suppose, if you do end up in litigation or if you think there's going to be a leak for nefarious reasons or otherwise. But in that scenario, it would make sense to have a PR firm lined up potentially, or at the very least, some reactive statements ready and drafted so that you're not caught on the hop, and so that you're best placed to really manage any potential reputation.
Yeah, and I would add to that that I would say your internal PR, if you have it, is one of somebody you want to bring into the fold pretty early on, so that they're aware of what's happening and can react to a leak if necessary. But then the other point is that you have a think about, if it does get out into the public domain, you're going to have queries coming in, not just maybe from the general public, but also from investors. So making sure your investor relations team is made aware of what's happening so that they can field those queries is really important as well.
Yeah, again, very, very important. Well, we are at time. Unfortunately, we've run out of time, so we can't answer any of the questions on this webinar. We'd like to say thank you very much. Hopefully you have got some helpful hints and tips if you're faced with a data theft scenario like this, or just to bolster your systems to prevent one in the future. If you have questions for us, either on the subject of employee data theft or more generally, there will be a link in the follow-up email to you to put 15 minutes in our diaries to discuss it. Leaves me just to say thank you very much. Thank you, Martin and Sharon. I hope you've enjoyed this session, and we will see you at the next Flash webinar.